adjunct lecturer, Ashesi University. Thank you very much for your time, and a good morning to you, sir.
Yeah, good morning. Good morning, sir. How are you?
I am fine. I hope you are too.
By His grace.
In fact, one of the things that we have constantly been discussing alongside what was transpiring in Parliament was the suggestion that there were tensions in town in Ghana because of what was happening in Parliament. Yesterday, we even saw one of the MPs deploy hundreds of his constituents in Parliament. Do you agree that this matter unnecessarily raised tensions?
Yeah, it's true. There's no doubt that we have tension in town, but I think this is artificially created, I believe. We need not to get to this stage if our politicians are honest with themselves and speak to the truth. I believe the issue at the center of this matter has to do with Article 97 of the Constitution. Of course, 1992 Constitution. And it has to do with the articles of G and H. On top of my head, I believe the article suggests that if a member of a political party shall vacate, it shall vacate his seat if, in the case of G, he leaves the party of which he was a member at the time of election to join another, or 6, to remain in the party as an independent candidate, or if it is the case of an independent candidate joining a political party. I thought this ought to be a straightforward matter, but as usual, because of the zero-sum politics that we have in our country, it's like the ruling government wants to have its way as usual. I believe there was an earlier experience in 2020 under Speaker Mark Okwe. There wasn't any hula baloo at that time, possibly because they had the numbers, so it wasn't a problem. But sometimes I also question sometimes I question myself whether the difference between the sitting president and President Dramani Mahama, as far as the 2020 election is concerned, it's about 500,000. So sometimes I ask myself, that with this number of votes difference, how come that the ruling government doesn't have a clear, simple majority in Parliament? But maybe that's a subject for another day. But in the current context, I believe that the ruling government seems to have shot itself in the foot. Because the noise being made at the moment, we didn't hear it the last time. And funny enough, some of their analysis or legal experts are even suggesting that the whole idea is futuristic, and that if somebody were to fill a form to indicate his or her intention to contest, that suggests that should only apply as far as the next election is concerned. That looks a bit weird, because you cannot read that kind of meaning into Article 97 GH. Definitely, if we were to even start from the individual party constitution or party position, it is clear that the individual political parties, whether NDC or NPP, it is clear in their own constitution that if you were to stand to contest against the officially known party member, you automatically forfeit your position. So, I'm not aware of any party provision contravening the national constitution. So, meaning whatever is in their own constitution definitely fits into the national constitution. And in this case, we're talking about the 1992 constitution. So, as to how people will read futuristic intention into this, beats everybody's imagination. But I think that the governing party seems to have shot itself in the foot. And unfortunately, the judiciary seems not to help matters. They seem to be entertaining anything that comes from the government. Here we are being told that there's a need to restore values of representation as far as the constituency is concerned in the current situation. But not too long ago, we know the same Supreme Court denied the people of Ashesi North of representation up to the time that Honorable Jachi Question was ordered not to hold himself as an elected member of parliament. So where has the virtues of representation gone at that time? We know of the case of SAL. For 4 years, a section of the Ghanaian public was denied representation. So for the whole session of this 7th parliament, the people of SAL are not being represented. We didn't hear anybody cry on their behalf. But today, a couple of months for the 7th parliament to come to an end, and we are being told that the 4 affected MPs must be allowed to represent their people. That shows that the judiciary itself is not helping matters. And I think that we need to speak truth to power.
And I'll come to the judiciary.
Yeah.
But you're suggesting that this kind of tension was artificially created, because we've heard from the Peace Council, I've heard CDD even ask the Speaker to just accept the decision of Parliament so that there will be peace in the country. If you're suggesting that this was artificially created, those interventions, first of all, are shocking, and secondly, to benefit who?
It's simply the ruling government wants to have its way, right? Like I mentioned the zero, some game that they always play. Whatever situation they find themselves, they always want to be, to have their way. And I think that's what is bringing the situation. You know that if we are to go by the ruling of the Speaker, which is what stands as of now, as far as records in Parliament is concerned, it is going to change the dynamics in Parliament. The previously held group, which was minority, will now become majority, and then the majority become minority. And I think this is what the government does not want to agree to. And of course, that will filter down to the various committees. As soon as that nomenclature changes, it means that even in the various committees that serve in Parliament, the positions is going to change. So it's like the whole architecture of Parliament is going to change. And I believe that government is afraid that it will affect its business, particularly when the opposition is already giving indications about cancelling, the betting tax, removing the e-levy, and so on and so forth. Believe me, these are already, budget, tax lines that are supporting the budget. So, if the opposition gets its way to become the majority and they start a process like that, we may not know how it is going to end. Even though we know at the end of the day, the president will still have to sign whatever bills that come out of Parliament. But you can imagine that if these tax revenues are taken out of the budget, it's definitely going to affect the spending power of the government. So that definitely brings a problem. Yeah. As far as security is concerned, unfortunately, I think we saw somehow some passing of party supporters, for whatever reasons, is best known to the organizers. I think that wasn't good enough. Already, if you look at even the press release that came yesterday before the sitting started, there seems to be some assistance sought by the marshal asking that order is going to be kept in a particular manner. I don't think there was any provision for people to bring in mass people, for that matter, to the scene. You can imagine if the NDC had also done a similar thing, there could have been a clash. And I think whoever did that must bow his or her head down in shame. It wasn't good enough. As leaders, it's good for them to set examples. And we know even the very constitutional provision has become a battleground. Why would you bring ordinary people who do not even understand the text of the Constitution? And it's already creating difficulties. And then you bring in supporters to Parliament If the other side also brings, definitely there's going to be a clash. I think our leaders should act a bit more responsibly.
And you pointed that out, but Olumide can still insists, despite the fact that the persons who were brought in were wearing MPP t-shirts, were MPP members, that they were the peaceful side.
Well, as for Afenyamarkin, he's another, I don't know. I don't want to subject his personality to discussion, but definitely I think his leadership style is a bit questionable. He still has a lot to do. Somehow, part of the engagement he granted the media yesterday was to say MPP was a peaceful party. I don't know if Afenyamarkin was in this country during the 2020 election. And what has his party done as far as the death of 8 people are concerned till today? I don't know if Afenyamarkin was in this country during the Ayawa's West Wagon. Recently, there was another clash at Mamobi. It was obvious that the shooting came from their side. So it's one thing to talk about these things, but in reality, your actions do not support what you are saying. Your actions seem totally opposed. Earlier on, I made reference to the arrangement made by the Marshal that Parliament will be open at 8 o'clock or so. But it was clear that we saw video clips of Honorable Anodempoe sitting in Parliament before 8 o'clock. So people who would not defy rules and come out and say that, oh, they are peace abiding. No, your actions should support what you say. But you don't say one thing and act in the opposite. And there are several examples I can give as far as their party is concerned. But that's not the business of the day. I believe that leaders must back their words. Their words with action, and that action must be truthful, must be honest to society. That is the only way we can have peace. But when we say one thing and do the opposite, that is not good for our democracy. At the moment, I believe our democracy is being challenged. We'll weather the storm, but let's see how it goes. As it stands, I also believe that we should not jeopardize the separation of powers. It is clear that we have 3 arms of government, co-equal, and they must respect each other. And that is the extent to which I feel that the Supreme Court even ought not to have entertained Afenyamarkin's, application, which seems to have even gone to the court prior to the Speaker speaking to the matter. But as at the time Afenyamarkin went to court, it was only Haruna Idrisu who seemed to have spoken in Tamale about what was going to happen. So how could you have gone to court on the basis of somebody speaking on the campaign platform? But it was entertained, and that was a bit shocking. It is even clear that from the ruling of the Supreme Court, they even relied on the draft Hansard, which has brought in a query to, I think, a staff of Parliament as we talk. So a document which the Supreme Court relied on was still yet to be approved or sanctioned, and yet the Supreme Court accepted such a document. I think that also it doesn't speak well for the Supreme Court.
Let me then ask you what you make of the Speaker's ultimate move to just adjourn Parliament indefinitely. Was that for you the best way of handling the problem?
Yeah, that seems to be a middle ground for now. I guess he did not want to be seen maybe opposing whatever ruling the Supreme Court gave. And I understand he has also asked his lawyers to put in an application to state his side of the story, so that once there's an attempt by the Speaker somehow to disagree with the position of the Supreme Court, that process will also be set in motion, and then we'll see how it goes on. For now, at least, he has stayed away from deepening the controversy, hoping that maybe cool heads will prevail. So let's see what the Supreme Court will say as far as the Speaker's application is concerned, and then from there we'll take it on. But I think for now, it is a middle ground, and then we'll see what will happen. Even though we know the consequences that government business is going to suffer. But who has caused it? it is the same government officials or people on the side of government who initiated this whole process. Maybe if they had discussed at their own level, probably sat down with the speaker, maybe the outcome could have been different. But I believe that it was a simple matter to the extent that from an ordinary point of view, Article 97 says the individual shall vacate. It says it shall vacate. So you don't even need somebody to prompt you. The moment you put in the action to file on another party or to become an independent candidate, the provision says you shall vacate your position. So I don't know why people are now saying that that's only the intention that is on the table. I don't know whether they are forgotten that when even judges questions, nationality, the certification did not come early. The court, you remember, the court went back to about August or so. That even the very moment he was filling the form to become a candidate, at the time that his certification had not arrived, he had already started the process. So using the same logic, in this instance, to the extent that the individuals are filing their applications, there is a notice of poll published by the Electoral Commission, then they've already shown that they are no longer loyal to their previous party. Or if it's an independent candidate, that individual does not want to stand as an independent candidate anymore, but to join a political party. So your loyalty is now divided. So it ought not to be something that we should argue about, particularly so when just 4 years ago we had a similar situation and there wasn't any noise. Why now? I believe it is because the dynamics in Parliament is going to change, and that's why we have this on hand.
And let me conclude then by asking you about the signals picked from this whole, what has happened. It's been about a week, within 1 week.
Yeah.
One, the public uproar when people saw the military anywhere near Parliament. The military later have to come and explain themselves. We're going to an election where at some point the military may be needed. It seems the public are not big fans of the military. Secondly, the Supreme Court intervention only annoyed people the more. It seems people don't even want to hear the Supreme Court's name when something of such nature is happening. The Supreme Court is supposed to be the final arbiter on this kind of matters.
Yes.
Should we be worried about what that portends for the Kabi election?
Yeah, we need to be worried. Particularly, like I told you, we have a government that always wants to have its way. Personally, I wasn't happy with this military situation. There's no way that we can justify it. I read there was a press release that there was a request from Parliament. Even there, are we saying that the police is not capable? Have we forgotten what happened on the night of 6th January? That we had military invading in the chambers of Parliament? That is not fair. Ideally, internal security is in the hands of the police. And I think Parliament has its own security unit. That's the Marshal. And it is when they are unable to contain a situation that they will call on the police. That would have been better. But to have military men dressed and roaming within the precincts of Parliament, that's not good enough. Part of the explanation was that they were going to check for explosives, etc. Are we saying that the police hasn't got that capability? They don't have that technology? And in any case, isn't it possible for even the same military to be in plain clothes? Because you cannot have uniform police within the precincts of Parliament. It doesn't speak well of a democracy. And I think that those who took that decision must look at it again. If you think you need the services of the military in a way which the police will not have or do not have, probably they might go in plain clothes to check whatever explosives you think you want to check, and that will be better. Of course, the anger about the public with the Supreme Court is because of their own conduct. There are instances of cases pending in the court now. They seem to be silent about it, kept it under the table and gathering dust. And yet other cases will come before them, and with the speed of light, they are already, attending to it. In the current case, it was less than 24 hours. And they even start on a Friday, where lawyers are telling us that usually the Supreme Court does not sit on Friday. We know not quite long ago we have this issue of LGBTQ plus, right? That is also pending, and it appears to the ordinary mind that the Supreme Court is dragging its feet. I'm aware there is even a pending case on the legality of the e-levy, which was sent by Honorable Hanra Idrisu, Honorable Ablakwa, and I believe Honorable Ayerga. And it borders on the number. Earlier in 2022, I believe, the 2022 budget, at the time that the then majority walked out of Parliament, it took the then minority to reject the budget. As usual, like the baby boy who ran to the mother for assistance, they went to the Supreme Court, and that decision was reversed, and that they ought to have been 138. 138 million would have been the quorum for them to take a decision. So that became a law. As nature will have it, a couple of months later, they passed e-levy in what appears to be with a lesser number. Reports suggest that there were actually 136 NPP members in Parliament. So this is the same Supreme Court who took an earlier decision saying that there were 137 members of NDC who rejected the budget. That number was not sufficient. It wasn't sufficient to make a decision. Now you have 136 making a decision to pass e-levy. And the same Supreme Court has sat on same till present. I believe the case is about 2 years now plus. So when you have a Supreme Court with that kind of attitude, or that kind of working style, it doesn't speak well for our democracy. Definitely, you are going to incur the anger of the ordinary person. And I believe there are several examples that I can point to. As far as if you look at even the SAL that we mentioned earlier on, how SAL was also treated at the Supreme Court was another matter. So sometimes the attitude and the way the Supreme Court handles matters is not helpful, and I think they need to change their ways, because we are told that justice must not only be done, but must be seen to be done. So in the process of dispensing justice, it is important that whatever processes that you embark on in order to ensure justice, those processes must be fair, must be diligent, and must be obvious to the ordinary mind. And the lawyers will tell you that the processes are as important as the final decision that you are going to make on a case. So that if the processes are faulty, they are suspicious, they are seen to be biased, and so on and so forth, at the end of the day, whatever verdict you give at the end of the case, people will have concerns because they've seen very glaring, faulty processes as far as your handling of the case is concerned. And I want to plead that our Supreme Court must look at themselves. They are the ultimate as far as justice is concerned. Yes, the sitting government might have appointed some of you, but that is just what the Constitution says. At the end of the day, as long as you occupy the seat, the seal of the state is what you should work at. Ghana should not be the focus and not the authorities that appointed you. Unfortunately, I think this is the challenge that we have as far as this judiciary is concerned. And that seems to really reflect in other instances. Take the Electoral Commission, the same thing. The very first step of appointing party loyalists, etc., into the commission is already creating concerns. So whatever the work the EC finally does, believe me, it will take a miracle to have 100% trust.
Thank you very much for speaking to us this morning.
Thank you, Senator.
Well, that's Alhaji Dr. Aminu Shittu, who is retired peace keeping officer, adjunct lecturer, Ashesi.